So welcome class, we are going to discuss KASNEB CPA Foundation Level, CSCCP, Introduction to Law and Governance, and this is August 2022 paper, question 6. Now explain six circumstances under which an insurance contract might be terminated. Explain six circumstances under which an insurance contract might be terminated. Now, number one, termination of an insurance contract. Number one, an insurance contract can be terminated by the sale of the insured object. The moment you sell the insured object, once it changes ownership, that insurance contract ceases to exist, so it's terminated automatically. So sale of the insured object leads to termination of the contract or the sale of the subject matter. Then number two, you can also talk of operation of law. By operation of law, and by operation of law we mean even something like the winding up of the insurer. If the insurer winds up, then automatically the relationship, the insurance contract comes to a dead end. That is a winding up of the insurer, and that can be as a result of operation of law. Then the other reason that may lead to termination of insurance contract is lapse of time. Normally the insurance contracts are done on a yearly basis. And so once a year comes to an end and it's not renewed, automatically that means that the insurance contract has come to an end. It automatically gets terminated when the year ends and it has not been renewed. Then the other reason would be breach of condition or warranty. Breach of condition or warranty. And this one goes right to the fabric of the contract, especially when you fail to disclose some information which is very pertinent in the decision making or underwriting process of the insurance contract. We talk of uberimae fidei, where you are supposed to disclose all material facts relevant in the decision making at the time of underwriting. So if you didn't disclose any of those relevant information, key pertinent information, you can talk of breach of contract, breach of condition or warranty, and that automatically can end the can end up in an insurance contract being terminated anytime, so long as the other party initiates the process. Then we also have this obvious one where the parties can talk of, let's first of all talk of illegality of the subject matter. If the subject matter, yes, you might have entered into a contract when it's legal, but when it's declared illegal, automatically that contract comes to an end. So whatever it is that you are dealing with, if it's declared illegal by the government of the day, then that contract comes to a dead end. It's terminated. And it's also on the same breath that we can also talk of no legal capacity to enter into contracts. If one of the parties lacks the legal capacity to enter into a contract or maintain a contract, for example, one of the maybe the insured goes insane, talk of unsound mind, then in such like cases the contract is terminated, because you cannot enter into a contract with a person who is not of sound mind. Then we also have payment of indemnity, especially if you are talking about full compensation as a result of total loss. When the insurance company compensates you in full as a result of total loss, that contract comes to an end and you start a fresh new contract if there is need for that if you agree on that. So that those are I think those are enough points. Those are around 7. I can see 7 points. Those should be enough to help us get these marks that the examiner is ready to give us. Then we move to the next item. Describe sectional properties. Describe sectional properties. Describe sectional properties. Now, this is a new law that has been set up basically to allow, it's a new law to set up to allow to allow individual owners for units, especially where we have multiple units owned by different people. Multiple units owned by different people. And the case in point is where we have one-story building, or these skyscrapers, one-story building with so many units in it. These units can be sold to different people, and then each of these people will have the ownership rights for his or her unit, so that he can even use that as collateral for future engagements. He can transfer it to anybody else. Basically, sectional properties allows a person to have the ownership rights to a certain unit from the so many other units that exist in that same property. So if we have 30 units in one building, one-story building, for example, you can just own one unit and have all the documentation rights for that particular unit, which might allow you even to transact with other third parties, because it basically, the law appreciates that is your property and you own it, and so you can transact it in any way, so long as it is in line with the laws of the land. So basically what the sectional properties does is that it seeks to subdivide buildings into units to be owned by individual proprietors, and common property to be owned jointly by proprietors as tenants in common. So if you're talking about so many units, you can own the so many units as tenants in common jointly, but you have the right to own your individual unit as a person and do as it pleases with you, so long as it's within the laws of the land. So outline 4 roles of lawyers in land transactions. Outline 4 roles of lawyers in land transaction. Now, number 1 role of lawyers is that they are your managers. Lawyers become your managers in these land transactions. They are supposed to transact on your behalf, not necessarily to transact, but to negotiate. They are supposed to negotiate on your behalf. They look for the best land and negotiate on your behalf for the best. They look for the best land and negotiate on your behalf for the best terms and conditions. So basically, they are in charge of the entire contract to ensure that it does well. And then they are also researchers. They are supposed to do a lot of research to identify the real ownership of the land before they can go ahead and enter into transactional, that kind of the contractual kind of relationship. So they are supposed to do enough research to identify the real ownership of the land, and if there are any encumbrances in that land, and basically anything that any information that might be of relevance to that contract that is yet to be entered, they need to have such pertinent information for decision-making purposes. They are also they review the transaction. Basically, they carry out and review the transactions related to the sale of land. So for you, you will be buying land or you'll be selling land, whichever side you are in. These are the people who will lead the transaction process and also review to ensure that it captures all the necessary and relevant documentation, all the necessary and relevant documentation. Yeah. So they will review the transactions and also carry out the transactions to ensure that it captures all the necessary, nothing is left untouched. Remember, in a sale of land, anything that you leave, any contract at that, any information you leave unattended might be used against you. So it's always good to have experienced people to follow all these transactions and review to ensure that everything has been captured in the right way possible. They also help in the transfer process of the property in question. Transfer process of the property in question. Now, there's quite a lot. There's an issue of stamp duties. There's an issue of change of ownership. There's quite a lot. So the whole of that process, these are the people who will carry out that process at your convenience and just give you the end result, which is the title deed. So they do the transfer process of the property, and they also become the custodians of all the documentation, all the property documentations. And this one, possibly if you are going to continue the relationship, or even if you are not going to continue the relationship, they will basically be transacting on your behalf. So they will hold all these files for you to be handed over the last day. But the best, and even if they hand it over, they always have the copies remaining with them in case of anything. So they just remain the custodians of your property documentations. And then there are also the property advisors in case you want to sell again. Property advisors in case you want to sell again, or in case maybe the terms and conditions change. Or in case maybe you are unable to play your part, what you had agreed. Maybe if you're talking about a bank, you had negotiated with the bank, had financed you, and you are unable to service the bank loans. They are the people who will come to your aid and talk to the bank and revise the terms and conditions. So they remain property advisors and work with you for as long as it takes to finally enable you get the full ownership to the property. So these are just some of the roles the examiner wanted for. Just pick any and you'll be good to go. Let's go to the last bit of this question. Discuss 4 advantages of the doctrine of stare decisis. Stare decisis simply means let the decision remain, and normally it's used. It's used in case laws, where the decision of the high court, the decision of a higher court, is used in the lower courts. So how a case was decided by a higher court will be basically mean that the lower court can also decide based on the same judgment, so long as the premises are the same, so long as the incidences, the situation, after considering, you find that they are similar, you can apply the same decision that was applied by a court of higher ranking to a similar case in a court of lower ranking. So this simply means that let the decision remain, let the decision stand. So you apply it as it is. And this is where the judgment of a higher court applies to a lower court. Now, what are the advantages of this? Number 1, certainty and predictability in decision making. Where you can argue out that in a certain case it was decided like this, and so it should also apply to, definitely it should also apply here, being a court of lower ranking. So it basically gives us a platform to predict the decisions or the judgment that is going to be made by a certain court, or especially of a lower ranking. Then the other advantage of this is consistency in law application, consistency in law application, so that we don't have a lot of, inconsistency. Today you say this, the other day you say this. At least there should be some uniformity in the way the law is being applied. So it ensures consistency. Of course, this one comes up also with fairness, that there will be fairness. The way the other person possibly, if it was for the best interest of the other person, it should also be for the best interest of me also. So there is some fairness, there is some practicality. It's practical because these are things that have happened to somebody else, and so they can also happen to anybody else. So you just borrow from that situation to this situation. They are live, and it's also an extension of law, because not everything will have to be captured in constitution or captured in through the statute. People evolve, and cases come up every day. So this one can help us to at least tap onto those new emerging cases in the society. And again, still in line with that, flexibility. There's some room for flexibility, where the court of higher ranking is not bound by a decision of a lower ranking court, and so this allows flexibility. They can it's basically a platform for coming up with a new judgment for such like cases. And then of course you have it also leads to reliance on judicial decisions, reliance on judicial decisions. Yep, it leads to reliance on judicial decisions, especially if you know that what was decided in that court will also be bound on any other courts below. And it also adds some seriousness and in-depth thought and research by this court of higher ranking, because they know that anything they will decide here will form a precedent in all the lower courts. So it calls for thorough research and independence when you are issuing out these judgments, as opposed to just doing things thinking that they will just end up in your desk. No, anything you do as a judge in a court of higher ranking will be used by by the subordinate courts, and so it calls for thorough research and seriousness when you are dispensing justice. So I think these are enough points. Just pick any 4 and we'll be good to go. Thank you.